The U.S. as a federal republic. What does that actually mean for the law?
Well, essentially, you've got 50 states, all operating under one supreme law. And that law is primarily enshrined in the U.S. Constitution.
Which is incredible, right? It's the oldest written constitution still enforced globally. Just this foundational document built on 7 main sections, the articles, and then updated 27 times through amendments.
Including the first 10, the Bill of Rights, which are so crucial for individual liberties.
Absolutely.
And those articles, they aren't just historical text, they really embody foundational ideas. Ideas specifically designed to prevent too much power from gathering in one place.
Okay, so how does that work?
Well, first, we see this with the separation of powers. Articles 1 and 3 divide the federal government into 3 distinct branches. You've got the legislative, which is Congress making laws.
Right.
The executive, led by the president, enforcing laws.
Okay.
And the judicial, that's the Supreme Court and other federal courts, interpreting laws. Each has its own distinct function, its own lane, so to speak.
Got it. And that's different from the division of powers, right?
Exactly. Separation is about the branches within the federal government. Division is about splitting authority between the national or federal government and the individual state governments.
So layers of separation.
Precisely. It's a crucial distinction that helps keep power decentralized.
And what holds it all together stops one part from overpowering the others.
That's where checks and balances come in, designed to stop any one branch from becoming too dominant.
Can you give an example?
Sure. Congress passes laws, right, but the president can veto them. Then Congress isn't powerless. They can override that veto, but it takes a hefty 2/3 vote in both houses.
Okay, so a high bar.
A very high bar. Or think about how the president appoints judges and makes treaties. Big powers.
Yeah.
But the Senate has to give its consent. They get a say. And even the Supreme Court, with its huge power of judicial review, which we'll definitely get into, its actual jurisdiction, the kinds of cases it can hear, is granted by Congress.
Right. So if we connect this to the bigger picture, these principles aren't just abstract ideas you read about in a textbook.
Not at all. They're the active, living safeguards constantly at play, protecting against concentrated power in our everyday lives.
Okay, let's zoom out for a moment then. Have you ever wondered why legal systems in different countries can feel so incredibly different?
It's a great question. Globally, you can roughly group legal systems into 3 main families: civil law, common law, and Islamic law.
And the U.S. system, where does it fit?
It's primarily a common law jurisdiction, and that really sets it apart from a lot of the world, especially continental Europe.
Okay, common law. What's the core difference there compared to, say, civil law?
It's a fundamental distinction, and it shapes everything, from how lawyers are trained to how judges make decisions. In civilian jurisdictions, think France, Germany, much of Latin America, Egypt, the primary source of law is legislation.
So written laws, codes.
Exactly. Comprehensive, codified statutes and codes. Case law, meaning previous judicial decisions, usually plays a secondary role. This system really prioritizes predictability and stability. The idea is that a complete, coherent set of codes can govern pretty much all legal relationships.
And how do judges work in that system?
Judges there interpret the legislation, sometimes quite broadly, to fit new situations. They tend to think deductively. Start with a general principle from the code, then apply it to the specific facts to reach a conclusion.
So a lawyer in, say, France would literally start by looking up the specific legal code book.
Find the relevant article.
And then figure out how it applies to their client's situation.
That's generally the approach. Now, flip that. In common law jurisdictions like the US and the UK, the law is mostly uncodified.
Meaning not all in one big book.
Right. Its main source isn't primarily a set of codes, but rather judicial decisions, what we call case law. These decisions act as precedent.
Okay, precedent. Like what happened before matters.
Tremendously. Of course, legislation still exists, and it does overrule prior case law if there's a direct conflict. But common law lawyers often interpret those statutes quite narrowly. The system is generally seen as more flexible because it gives more weight to the specific facts of individual cases.
And here's where it gets really interesting. The different ways lawyers are trained to think about the law itself. So if it's not all written down in codes, how do you get predictability in common law?
That's where a principle called stare decisis comes in. It's Latin, basically means to stand by things decided.
Stand by precedent.
Exactly. It's the policy that ensures similar cases are decided similarly over time. that provides consistency and a form of predictability.
Okay, so it's not random.
Not at all. It means that while courts do have some liberty in interpreting legislation, they're generally bound by previous rulings from higher courts in similar cases. Common law reasoning is interesting. It's a blend. It uses inductive thinking.
Specific to general.
Yes, moving from specific facts or observations in cases to broader legal principles. It also uses deductive thinking, like civil law.
General to specific.
Right. And, importantly, analogical reasoning, comparing the facts of different cases to figure out how a new situation should be treated based on past ones.
So a common law lawyer here in the U.S., when they get a case, they're probably going to start by
Researching other similar cases first. See what judges decided before. Whereas, like we said, a civilian lawyer often dives straight into the legislative codes first.
fascinating difference in approach.